Those keeping up with us know that we have also been running two series called the Appalachian Outlaws and the Appalachian Feuds. We do a massive amount of research on everything that we have topics about. While researching out one of our feuds, we came across this article in the Big Stone Gap Post on February 16, 1893. At this time, Dr. Marshall Benton Taylor had been convicted of murder in the first degree for the Pound Gap Massacre. According to all sources, this conviction was based solely upon the jury's examination of his rifle. They had taken apart the rifle without the defense lawyers, the prosecution, or Taylor being present. This should have automatically caused a mistrial. We have seen the affidavits from several of the jurors, the sheriff, and his deputy to this fact and how it affected the jury's decision of guilt. While Taylor's sentence was supposed to be carried out in December of 1892, he received a last-minute stay of execution while his case made its way through the appellate court in Wytheville, Virginia. This case would be heard in July of 1893. In the meantime, Taylor's lead attorney, Judge T. M. Alderson, and Taylor gave interviews speaking about the same thing. We have chosen to give you the attorney's interview as it is found in the Big Stone Gap Post. Between the two, it carries more weight to the particulars of the case. The only differences between the two interviews is that Taylor maintained his innocence throughout the interview and insisted he had been wrongfully charged and convicted of the crime by his enemies. Judge T. M. Alderson Interview, Part 1. Quote, the Dr. Taylor case. Judge T. M. Alderson of Wise Courthouse came down Sunday and went over in Bristol on Monday's early train. Judge Alderson vigorously defended Dr. Taylor in his late trial for the Pound Gap Massacre and says, while he is convinced the jurymen in the case acted in accordance with their honest convictions, still he does not think the evidence in the case justified the verdict rendered. In referring to the different errors pointed out in the bill prepared and presented by himself and associates to the higher court asking for a new trial, he said of the 8 pointed out, he thought that there was one alone sufficient to give them good grounds to expect a favorable decision, unquote. For the first time, we learned what Dr. Taylor's attorneys thought about the case and what was to be expected. Judge Alderson seemed hopeful that one of the 12 exceptions that they had raised would overturn the conviction and cause Wise County to either retry or dismiss the case. In no way does the judge give any hints that the jury acted with malice or animosity toward Dr. Taylor. He states that he felt that they had acted as honest men. However, he feels that there are simply not enough evidence to merit a conviction of first-degree murder in this case. Although the attorneys would write out the exceptions to the case, it was up to the judge to sign off on them and attach them to the transcript of the trial and prepare the appeal for the appellate court. Did Judge Samuel Williams fail to do his duty? Just like Charles Johnson, we were shocked that the 12 exceptions written out by Dr. Taylor's attorneys were not attached to the transcript. At the time, it would have been Judge Williams' duty to ensure the accuracy of the transcript. He would also be responsible to ensure that all affidavits and other paperwork were included in the appeal before being sent to the appellate court. Did he feel that the conviction was correct and that there were no errors at bar? Could this be why there is nothing but affidavits attached to the transcript? We have no answer for this, simply questions. However, if Judge Williams had done his duty, we question where and when the exceptions became lost. And what about the accuracy of the transcript? We believe that we have found and pointed out ample evidence of ex post facto and other editing throughout the transcript. Remember, other than the appellate court, after Judge Williams signed off on the appeal, no one was ever expected to see the transcript or any other paperwork that went along with it. That is until former Wise County Court Clerk Charles A. Johnson decided to write a book and include the story about the Pound Gap Massacre. Judge T.M. Alderson interview, Part 2. Continuing with the newspaper article. Quote, in this, he referred to the fact that 3 cartridge holes were picked up on the ground of the bloody massacre where the 5 people were murdered from ambush, that these holes were produced as evidence to show that they had been used in a gun the same caliber that is owned by Taylor, which was the case. These shells, on examination, showed that the plunger of the gun in which they were exploded had struck the hull on one side, when ordinarily they would have been struck in the center, had the gun been in perfect order. Taylor's gun was tested during the trial, and in 5 shots it was found that the plunger struck the hull directly in the center. Unquote. For the first time in this entire case, we now have the exact number of spent shell casings that was found at the crime scene. It has always been suggested that there were more than 5 and no more than a handful that was found, and that these casings were found under a pile of pine needles. This is very suspicious on many levels. Why, when there were hundreds of bullets that had been shot in less than 5-minute range, would there have only been 3 bullet casings found? The oft-told story tells us that these shell casings was as if a person emptied their gun into their hand, laid the shell casings down, and covered them with either pine needles or pine cones, depending on who is telling the story. How do we know this had to be done in less than 5 minutes? John Harrison Mullins tells us himself. Mullins says that he did not hear any shots being fired after he covered the distance of a half a mile. Imagine a 14 to 15-year-old, healthy, athletic young man who is being shot at running for his life down a mountainside. It would not be out of the ordinary for him to make a half a mile distance in less than 5 minutes. He had made a 7-mile journey in less than 30 minutes on foot running for his life. For him to run at that speed, he would have had to travel as fast as a horse at close to 20 miles per hour, which is normally physically impossible, as a person can run somewhere around 7.25 miles per hour. The current record holder, Usain Bolt, ran 27.5 miles per hour in a 100-meter dash. However, taking into account that he was running straight down a mountain instead of following a worn wagon road, this would have cut the distance significantly. In fairness, we think the distance that he could have been running would have been somewhere around 4 to 5 miles total. We also need to take into account that a handgun shot can be heard from a distance of over a mile away, depending upon conditions, and a rifle can be heard from a distance of 2 miles away. So we propose that since John Mullins did not hear any more shots after he had traveled the distance of a half a mile or more, then the shooting of the Mullins party had stopped at that point. And our next point is that the gun had been tested during the court proceedings with 5 bullets to make sure that the gun was either a center fire or rim fire. This determination was made by the testimony of the gunsmith, Deputy Sheriff Miller. Judge T.M. Alderson interview, Part 3. Continuing on with the newspaper article. Quote, after the case had been given to the jury and it had retired to consider the evidence, this point came up. The jury sent for the gun and, taking it to pieces, examined it out of court and in the absence of the prisoner, and thought they had discovered that it had recently been tampered with, which, Judge Alderson states, was one of the leading points which caused them to render a verdict of murder in the first degree. Unquote. Whoa! Wait a minute! Hold the phone, Sally! We have seen the affidavits that the rifle was handed over to the jury. They were allowed to take it apart and put it back together again without Dr. Taylor and or his attorneys being present. This should and did prompt the call for a mistrial from the defense. which was overruled by Judge Williams. In cases back then, as in today, the jury is not allowed to view the murder weapon or crime scene without the presence of the attorneys and/or defendant. This is to ensure that there is no tampering with the evidence, either on purpose or accidentally, by the jury to try to discover more evidence than what was presented by the court and witnesses. This very action taken by the jury is why Judge Alderson felt that the conviction would be overturned in the appellate court. Something missing. What? No mention of the testimony of Jane Mullins? Why did Judge Alderson not mention Jane in his statement? She, after all, was the prosecution's star witness against Dr. Taylor. And for 131 years, her testimony has stood in many of the tellings and retellings and most of the myths and legends surround her side of the story. But was it true? As we have previously stated and demonstrated, she had perjured herself on the witness stand, and the defense had done a pretty good job of tearing her story apart and proved it was false. Even the jury affidavits didn't consider it for the conviction of Dr. Taylor. I.N. Mills states in his affidavit that if it had not been for the examination of the rifle, the jury would have found Dr. Taylor innocent. Our question to everyone is this: why then is the testimony and story of Jane Mullins being retold over and over for 131 years? After all, in the transcript of the trial, she perjured herself and admitted that she told what she wanted to, when she wanted to. In other words, she herself admitted on the stand that she was a liar. From Judge Alderson's and Taylor's interview, it must have been a real shock when the appellate court refused to dismiss or retry the case due to the lack of evidence. It was the action of one of the appellate judges that stayed the execution, and from the newspaper accounts, the appellate trial consisted mostly of an argument between the Chief Justice and the judge that stayed the execution. We believe that the judge that granted the stay looked at the transcript and noticed that a lot of it did not make sense. But without those 12 exceptions, there was no evidence to grant a new trial based solely upon the transcript and the affidavits presented to the court as we have it today. Luckily, unlike the appellate court, we are able to look back at the story and the trial of the Pound Gap Massacre using the lens of hindsight. We at Kentucky Tennessee Living wish to thank you for reading and watching our series on the Killing Rock. Don't forget to hit that like button, as the more likes we receive, the more likely YouTube is to suggest our videos to other viewers. Also, to receive notification of future videos, be sure to subscribe and click the bell icon for notifications. We thank you for continuing to support Kentucky Tennessee Living as we bring to you the history of the Appalachian Mountains. We must remind everyone that the story names Killing Rock, the Oft-Told Tales, Killing Rock, the Untold Story, Killing Rock, the Trial, and Killing Rock, the Defense are all under Kentucky Tennessee Living copyright.